We have discussed the standard boiler clauses. We have discussed what is offer, acceptance, proposal, promise, agreement, contract. We have also discussed the type of agreements, which is void, voidable, and valid agreements. We have also discussed what are wagering contracts. We've also discussed contingent contracts also. Contingent contracts, if we have not discussed, let us first understand that. Contingent contracts are also a similar contract which is based on a condition or something that is supposed to happen or may not happen. However, it is not a wagering contract. It is a valid contract and it is not illegal in the eyes of law. Moving on, this was a very brief about contingent contracts, but now this is a session about us understanding in reality what are the contracts are. So we have understood the basic clauses of a contract. How do you renew a contract or how do you amend a contract? So there's a very simple process. If parties consent to, an agreement can be renewed with a letter of renewal. Letter of renewal, how does that happen? What do you write in letter of renewal? Okay, so a letter of renewal can be made on a letterhead of a company. Okay. Second, this can just be directed to that party who intends to accept your offer, and you can send an offer. Example, I have been seeking services till the same example that we were taking. I have been seeking services till 30th May from ABC Private Limited. Now on 1st May 2023, I decide that I would want to renew these services with the other party. I connect with the other party or my business team. So I am a legal team person. My business team shall connect for renewal of services. Whosoever started the process of fetching the service provider. So it was decided that this company shall continue to provide us services for another year. Again, from 1st June 2023 to 30th May 2024, the next year. So in that case, we'll get a letterhead of our organization. I, as a legal person, will draft a small letter wherein I will, of course, address it to ABC Private Limited Company, their authorized signatory, their registered office address shall be mentioned. Subject shall be given as renewal of agreement dated. So you have to mention or refer the agreement. Then, of course, you mention you in the body of the letter. It's a very small letter that you state that, let's say, my company was MNC Private Limited. So this is the reference to MNC. This is a reference to an agreement between MNC Private Limited Company and ABC Private Limited Company, entered on this date, let's say 31st May 2022, entered on 31st May 2022 for the services of hospitality services to be deployed or provided at my head office located at the address office of the company, my company, MNC Private Limited, from the period this to this. We would like to mention that the agreement is hereby renewed further, or you can say the agreement is hereby further extended for a period of 1 year from 1st June 2023 to 2024. We request you to acknowledge this proposal or this letter of renewal and signed by your authorized signatory. Under that, you will give the details of the authorized signatory of the other company, leave some space for signature, put his designation, and then under that, you will not do anything. That is it. You've already given your company's address and your details. Wide your letterhead, because your letterhead will always have the details of the organization. Now, this was letter to renew. Similarly, letter to amend will also be there. So renew is only in the case when you would want to extend the services that you've been taking or you have taken. Letter to amend is when during the validity of the agreement, let's say, as we were discussing about manpower to be deployed. So the agreement was valid, as we were discussing, 1st June 2022 to 30th May 2023. And during that period, somewhere in September, October, August, whenever, I decide that I need more manpower or I need to have different services from the manpower. So I would mention that this agreement is hereby amended. Again, the first paragraph of the letter of renewal shall remain same, and the second paragraph shall be substituted as the agreement is hereby amended in the following manner. Now, the manpower shall be deployed here, 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 or the manpower shall provide me these services, or let's say the consideration between the parties shall be revised. So the consideration between the parties, as decided earlier, was 3 lakh rupees per year, is now revised to rupees 3,15,000 rupees per year, with effect from 1st June 2023, or let's say if you want to revise it in September, then 1st September 2022 of that year, while during the continuation of that period or the agreement, you can amend your agreement. Now, what is usually seen is when there is a gap between two agreements. Let's say I was taking services from this ABC Private Limited company in 2022 to 23. Now, I have not taken services from 2023 to 2025, and now in 2025, somewhere in September 2025, I realized that ABC Private Limited company was a good company, and I would want to continue taking services from that organization. So, what is usually seen is that you have a fresh agreement. So, again, you cannot renew in these cases. In this case, it is preferred and it is stated and it is suggested that you should again have an agreement, probably with the same terms and conditions or revised terms and conditions as the negotiation happened between the parties. Now, again, when you have an agreement in 2025 with the party, there will be a mutual consent between the parties, probably through telephonic conversations or emails, or however is your mode of communication, through any medium, which usually in a case of a company is express offer and acceptance. As we explained what is express and offer, I don't think I need to repeat it. So in case you still want to have a hint, that was something which is written is an express offer and acceptance. So we have discussed almost everything. What else can we discuss? We have already discussed a manpower agreement. How do you define a manpower agreement? We have discussed a service agreement. We have discussed boilerplate clauses. We can discuss an employee agreement. So I think employee agreement to be discussed is very important right here, because I'm sure a lot of people who are having this session are either lawyers or are students, and once they will be employed, they should be well aware of what are the basic terms and conditions to be included or to be seen or to be observed in an employment agreement. So, of course, an employment agreement will again mention as boilerplate clauses the parties, the details of the parties, like this is this party, agreement enter between these two parties. There has to be a date which is effective, let's say an effective date, which is when the agreement formally starts. You may come for an interview on 5th May 2022, but your employment may begin on 15th May 2022. So the effective date is when you formally start to work with the organization. That is your effective date, and effective date has to be mentioned in each and every case, whether you're taking services, you're taking manpower, you're engaging an employer, you are having a retainer, you are taking supply of services. There is you're taking some goods or some products or anything. So there has to be an effective period or the term of execution. So again, the term of execution is the date of execution. The period of execution that we talk about is when the parties agree or consent to an agreement. Now, when it's an employment agreement, there are few things that you have to see. You have to see whether it has work timings being mentioned. So as per the labor laws, you have to see that your work hours are being given in your agreement, your employment agreement. Moving on, you will also see your job description, which is your key responsibility areas, KRAs, that what will you do for the organization for whatever period you work for or you're employed for. Probationary period has to be mentioned. So as per law, probationary period cannot be more than 6 months in an organization. So the maximum period of probation is 6 months, and probationary period can be of 1 month, 2 months, 3 months, deciding on the discretion of the organization, but maximum up to 6 months. There has to be a leave policy, whether if you are a permanent employee. If you are on the payroll of the company, then there is a leave policy which is like sick leave and casual leave and encashment leave, which is EL. If you're a contractual employee, there can be like some lump sum amount of leaves that maybe you have like 30 leaves in a year or 20 leaves in a year, and they may or may not be divided. But when you're on a payroll, there are defined leaves for you, sick leave and casual leave and ELs. Further, there has to be very, very important clause for anybody who's getting engaged in a company is remuneration, because one of the factors why we work for is money. So it has to mention that how much amount will you be paid. It could be monthly or it could be yearly mentioned. Termination shall be there. Oh, termination is also, I absolutely forgot to tell you, termination is a term, is a period when the agreement ends. Basically, when do you end an agreement, or on what grounds do you end an agreement? So termination is, I would terminate an agreement with you, the agreement that I entered with you. I would terminate it on the grounds that you are your company is insolvent now. Your company went into corruption. You had a merger with the other organization, or any force majeure situation has occurred, or anything that you could not perform services in a service agreement that we were discussing before. But how about an agreement with an employer or an employment agreement? In that case, of course, most of the times that you see a termination clause will come as non-performance of your services or your ill-mannered behavior. So if you are not up to the behavioral policy of the organization, or you're not performing well, then your agreement can be terminated. Term of the agreement has to be mentioned. So this agreement is valid for a period of 1 year, and that is how an employee is engaged in a company. Then that is why we have appraisals, and then there's like an appraisal meeting. Then you move on, then your contract is renewed for another 1 year or 2 year basis on whatever the discrete of the company. Jurisdiction is also one of the important clause in every agreement. Jurisdiction is where will the matter or where will the suit be filed in case there comes a dispute between the parties. Let's say there was an employee and then there was an employer, and the employee was fired, and there was a clause of jurisdiction that in case of any dispute between the parties, the matter shall be referred to the court of, let's say, Gurgaon, in Gurgaon. So that is the jurisdiction of the court. Now, the another form of jurisdiction that we see these days is also, another form of dispute resolution method that we see these days is a arbitration clause. So there are two ways of resolving your dispute. One is you go to the court, and the court that falls as per CPC section, which is 16 to 20, and you see section 16 to 20, and then you see the jurisdiction, and then you file your matter. Here, you do not decide your jurisdiction, or you may decide your jurisdiction and can say, in case of any dispute between the parties, the matter will be referred to the courts of Gurgaon or the courts of Delhi or the courts of Mumbai or Hyderabad or whatever. Usually, the company makes sure that the jurisdiction and is placed where the company's head office or the registered office is placed for their own convenience. Second way of dealing with the dispute resolution method is arbitration, wherein they say that in case of any dispute between the parties, the matters shall be referred via method of arbitration only in the courts of Delhi or in the courts of Gurgaon or in the courts of Mumbai, or wherever they would want this place of arbitration to be. The arbitration clause is very much valid, and once agreed, the parties have to go by it, and then the matter can only be filed in that particular arbitration jurisdiction only. Moving on, we have discussed IPR, which is supposed to be in an employment agreement as well, because of course the confidential information will be shared. We have discussed the confidentiality clause, which is important because you're an employee and you have to abide by the clauses, and you have to keep your information secure of the company. There is one of the clauses that we see, but it may or may not be an agreement, but I think we should still discuss it. It is called non-solicitation clause. Like if I hire some services from your organization, or I hire some manpower from your organization, so I should not solicit that person, that manpower, to my company. I should not indirectly take away your employee and then hire that person in my organization. So non-solicitation clause can vary for the term of the period, that during the term of the agreement between the parties, you cannot solicit my employee. If you need more clarification on solicitation, it is basically like services that we were discussing earlier, that I hire a company, the company is providing me manpower to give me certain services. Now that manpower is working in my organization, I should not lure that person that, you do not work for the other company, you work for my company directly. I should not solicit that person. A non-solicitation clause. So a non-solicitation clause in an agreement can be for the term of the agreement, can be for another 3 years or 2 years. Again, depends on the consent of both the parties and how the negotiations go by. Thank you.